Hello, so I'm here to tell you about the legal impact and the legal framework of e-governance. So the first question might be, why worry about the legal framework? Because it appears to be something that's pretty much technical. We're using more information communication technologies, ICTs, for governance. So what is the impact on this for law, and why should we worry about it? So my first message would be that it is really something that is very important. It is something that you should think about from the beginning, because if not, it risks to actually create obstacles. And as a lawyer working on e-governance, I'm very aware of how this is sometimes seen to be something that is an obstacle, because lawyers were seen, perhaps rightly, coming with lots of regulations and restrictions and sort of hindering fun developments. But this doesn't have to be the case. Actually, law can also have a facilitative role in helping e-governance, in aiding it to become something that's very useful. But if the right things are not taken into consideration from the beginning, it risks to become a hindrance later on. So I'm going to tell you a little bit about the different areas of law that are involved, and then in a separate lecture I will talk about some of the very important aspects of rights of privacy, data protection, and the protection of our human rights in the context of e-governance. But first of all, then a little bit about what are the different issues that are involved. The first message may be a surprising one to come from a lawyer, and that is that it is not a question of making lots of new laws. Actually, completely the opposite. And this is very important, because what we want to do is we want to make governance, e-governance, to support governance, not as a parallel system. Because the whole point of it is that it is to facilitate, to make more efficient, more effective. So if we would make a parallel system, this would have the opposite effect. It would just create duplication. So that is why it's not a good idea to make a law on e-governance. It's not a good idea to make separate laws on all forms of transactions in the e-world. At the same time, having said that, there are some issues where we do need separate legislation. The main one is how we identify ourselves in the e-world. And the reason we need separate legislation for that is that this is something that's quite different from the, say, the regular, the traditional, the offline world. We know already for generations how we identify ourselves. We do that by signatures. We do it by perhaps meeting the person, seeing whoever we are doing a transaction with in person, and maybe showing some identification. All of this evidently is different when we're doing things online. So this is one of those areas where we need to have legislation, because we need to make sure that this is a secure way of identifying ourselves, so that it can be known also in the electronic world who is doing some transaction. And I'm saying on purpose quite a general word as transaction, because this is actually the same when we're talking about e-commerce. So we need to identify what it is that is a valid signature in the e-world. Here it's a question of deciding on the technology, which is a technology matter. We see in all of these areas with e-governance how there is a close connection between law and technology. So it's a technological matter: which form of e-signature is recognized, how is it secure enough. But then it becomes a legal issue to ensure that this particular technology is what should be used and will be legally valid. To know what should be in such a law, it's important to understand from the lawyer's perspective what is a signature. It is a way of showing your intent. It is a way of showing that I am willing to do this transaction, whatever that transaction is, and take the consequences. And signatures are very different, whether it's an e-signature or a regular signature. If you write your name on a birthday card, or if you write your name on a contract to sell your property, it's something very different. And it's this kind of difference that should be reflected also in the e-world. So we need a law that stipulates how do we make the e-signature. what type of certifications are there? How do we know that these particular signatures are secure enough? And it's actually, in a way, would be maybe better to talk of e-identities rather than e-signatures, because it's not necessarily a signature in the traditional way, but still the terminology used is often e-signatures or digital signatures. So apart from this, identifying what forms of signatures or identities, what else then is needed from the legal viewpoint? As I said, not a lot of specialized legislation, but this doesn't mean that there wouldn't be work on the legal side for the legal experts, because it's very important to look at all the legislation, pretty much the whole legislation of the country, to see if there are any obstacles to introducing e-governance. There may be very simple things, like there might be a requirement of a certain look of a document, or there might be a requirement of having a stamp. And if there are no e-stamps, then it's not possible to go to e-transactions. It's not possible to have blue paper if we haven't said what is equivalent of blue paper in the e-world, for instance. So it's important to look through all legislation. Administrative, procedural legislation is very important to see, are there any obstacles. One very important thing that can be an obstacle to e-governance from the legal side in many countries is that electronic transactions don't have full value in court as evidence of something. And then obviously it's not possible to go to e-governance before that is sorted out. But this doesn't mean making necessarily new laws. It means looking at the laws and seeing what it is that might need to be changed in different laws, or perhaps to pass one can be very short, simple law, which says that wherever it says in a legal act that there should be a signature, there should be a document, then this can also be an electronic signature, an electronic document. So do that in one law, and then it applies to the whole legal framework. How this is done will vary from country to country. It has to do with traditions of how legislation is made and so, but the substance can be the same. So not to create necessarily new situations, but to make the legal framework suitable for the technology. And the very final thing I want to mention about the legal framework is that we also need to think about issues of competition and who it is who's actually providing these different services. Because we will have a very important role for internet service providers. We will have companies that are actually enabling the governance to be used, that may often be private companies. And for that there is a body of law which is called competition law, which regulates that there will not be any abuse of dominant position. Companies that carry out a special role for the public sector have a special role also from the legal sense. This is an area of law that already exists in most countries around the world. We have the general competition law, and then we have what's called sector-specific legislation on the communications sector. So shouldn't be anything new. Maybe there are no need for changes, but it's very important to look at this so that this is also adequate for e-governance. So thank you for your attention.